Hello aspirants, a very warm welcome to all of you. So let's begin आज का एविडेंस. सो होप आप सबने पिछली प्रीवियस वीडियोस भी जरूर देखी होंगी. आप लोग बस प्रैक्टिस करते रहिए, एमसीक्यूज मत छोड़िएगा. जितने ज़्यादा एमसीक्यूज हम लोग प्रैक्टिस करेंगे उतने ज़्यादा हमें कॉन्फिडेंस जनरेट होगा प्री के लिए, और कंसेप्ट क्लैरिटी भी हमारी साथ के साथ उसमें चलती रहती है. तो आज का हम सेशन स्टार्ट करते हैं विदाउट वेस्टिंग आवर टाइम. जो हमारी मोटो है, जो हमारा प्रिंसिपल है कि वेस्ट बिना बातों के करेंगे, लेकिन जो मैं आपको बोलता हूँ ये एक मोटिवेशन भी देता हूँ, आपको थोड़ा सा गाइड भी कर देता हूँ. तो जितनी मेरे पास नॉलेज है मैं आपको शेयर कर देता हूँ. तो लेट्स बिगिन विद आवर फर्स्ट क्वेश्चन. तो आज का फर्स्ट क्वेश्चन है कि जनरली बैंक डिक्लेरेशंस आर एडमिसिबल एज एविडेंस अंडर सेक्शन 20 ऑफ एविडेंस एक्ट, 25 ऑफ एविडेंस एक्ट, सेक्शन 32 ऑफ एविडेंस एक्ट, 35 ऑफ एविडेंस एक्ट. चलिए आंसर बताइए. होप आप सबने इसका करेक्ट ऑप्शन ही दिया होगा. सो इट्स सिंपल सा क्वेश्चन था, सेक्शन नंबर 32. So question number 2. Which of the following statements should true for dying declaration? Dying declarations cannot be used as a sole basis of conviction. Dying declaration, unless corroborated, cannot be used as a sole basis of conviction. Dying declaration which is brief must be discarded. When eyewitness affirms that the deceased was not in a fit state to make the declaration, medical opinion cannot prevail. तो चलिए इसका करेक्ट ऑप्शन बताइए. So hope you give the correct option. It's D. When eyewitness affirms that the deceased was not in a fit state to make the declaration, medical opinion cannot prevail. So next question, question number 3. In which of the following cases the evidence given by the witness will not be relevant under section 33 of the Indian Evidence Act? When the witness is staying abroad, witness is dead, when witness cannot be found, and when the witness is in coma. So ये भी simple question है, इसमें भी हम लोग waste नहीं करेंगे time. It's clearly states when the witness is staying abroad. वहाँ पे definitions नहीं है, 3-4 points दिए गए हैं 33 के अंदर है, 32 के अंदर भी, कि जब वो नहीं मिलता, डेड हो जाता है, उसकी बिना अनरीजनेबल एक्सपेंसेस के इसको नहीं मुआ बुला सकते, तो ये चीज़ें, बट वो स्टेइंग अब्रोड है, इसको नॉट. So अगला चलते हैं क्वेश्चन नंबर 4. Accused wants to submit a document for consideration under section 35 of the Evidence Act. In which of the following cases will the document become irrelevant? It does not deal with the fact in issue. It does not deal with the relevant fact. It is not an entry made in public or other official book, register or record. It is not an entry made by the public servant. चलिए करेक्ट ऑप्शन बताइए. So आप सबने आंसर ठीक दिया गया होगा. So its correct is C. It is not an entry made in public or other official book, register or record. Next question is question number 5. A party wants to set aside a judgment under section 44 of the Indian Evidence Act. In which of the following circumstances can he do so? In case the judgment was passed by the superior court, in case the person challenging is a stranger to the proceeding, in case the judgment was a result of gross negligence, and D, all of the above. तो चलिए करेक्ट ऑप्शन बताइए. Hope you give the correct option. It's A. In case the judgment was passed by superior court. Question, next question. According to section 61 of Indian Evidence Act, the contents of document must be proved by primary evidence. Contents of document must be proved by secondary evidence. Content of document must be proved by both primary and secondary evidence, and the contents of the document must be proved either by primary or secondary evidence. So बहुत ही अच्छा क्वेश्चन है, एक दो वर्ड का हेर फेर है. तो चलिए आप क्वेश्चन का आंसर दीजिए. So its correct option is option number D. इसका यहाँ पे either दिया गया है, यहाँ पे both दिया गया है, तो इसी चीज का बेसिक डिफरेंस है. ठीक है जी. तो नेक्स्ट चलते हैं. क्वेश्चन नंबर 7. Definition of secondary evidence has been given under dash of the Indian Evidence Act. 61, 62, 63, 64. Direct section based question. Option number C. Question number 7. ध्यान से सुनिएगा. B, an accused wants to submit carbon copy of the suicide note as a secondary evidence. The original is with the opposite party and he has failed to produce the same. The suicide was not within the knowledge of the accused prior to the receipt of carbon copy. Which of the following statement will hold true of the case? The evidence cannot be admitted due to applicability of section 30 of the Indian Evidence Act. The evidence cannot be admitted because it fails to satisfy the requirement of section 64. The evidence cannot be admitted because it fails to satisfy the requirement of section 65. The evidence can be admitted as it satisfies the requirement of both section 64 and 65. चलिए करेक्ट ऑप्शन दीजिए, बहुत ही अच्छा क्वेश्चन. So hope you gave the correct option. Eighth is D. So the evidence can be admitted as it satisfies the requirement of both section 64 and 65 of the Indian Evidence. Now next question is, according to section 65 of the Indian Evidence Act, the secondary evidence can be admitted in dash exceptional cases 3, 5, 7, 9. बहुत ही अच्छा क्वेश्चन है, बहुत ही देखने को सिंपल है बट बहुत अच्छा क्वेश्चन है. सो इसका करेक्ट ऑप्शन इज सी 7. Question number 10. Which of the following sections of the Indian Evidence give provisions regarding proof as to electronic signature? 67, 67A, B, C. कौन सा है बताइए? So its correct option is option number B. चलिए next चलते हैं. Question number 11. Which of the following section of the Indian Evidence Act deals with the proof of other official documents? 78, section 82, section 71, section 74. So the right question, simple. Next question is question number 12. Which of the following section of the Indian Evidence Act has been amended by the Criminal Law Amendment 2013? 32, 55, 119 and 124. So correct option is 119. Sorry. Next question. Which of the following statement hold true for section 154 of the Indian Evidence Act? The court is bound to give leave if the requirement are met. The witness must be declared hostile before making a plea under this section. The court can give the leave under this section suo motu and D, all of the above. So correct option is option number C. The court can give the leave under this section suo motu. Next question, question number 14. Which of the following question is proper under section 148 of the Evidence Act? If the imputation refers to matters remote in time, if the imputation refers to such matters that its truth does not affect the credibility of the witness, if they are of such nature that the truth of the imputation touches the credibility of the witness, if there is great disproportion between the importance of the imputations and the importance of the evidence. चलिए correct option बताइए. Correct option is option number C. If they are of such nature that the truth of the imputation touches the credibility of the witness. Now question number 15. ध्यान से पढ़िएगा, बहुत अच्छा क्वेश्चन है. During the cross-examination of the witness as to previous statement made before the police, all contradictions or omissions were brought on record, which were portions from the statement made before the police that were not deposed before the court. Which of the following statement will apply to the case? The credibility of the witness has been impeached under section 148. The credibility of the witness has been impeached under section 145. The credibility of the witness has not been impeached because the contradictions were not as contemplated under section 145, and the credibility of the witness has not been impeached because of the protection under section 154 of the Indian Evidence Act will apply. चलिए करेक्ट ऑप्शन दीजिए. सो अब आप सबने इसका अच्छा क्वेश्चन था, अच्छा ही आंसर दिया हुआ. सो ऑप्शन इज सी. The credibility of the witness has not been impeached because the contradictions were not as contemplated under section 145 of the evidence. A person summoned to produce a document does not become a witness in the case unless he is called as a witness, automatically becomes a witness in the case, automatically becomes an hostile witness in the case, and can be cross-examined without being called as a witness. चलिए 16 का करेक्ट ऑप्शन बताइए. So hope आप सबने करेक्ट ऑप्शन दिया होगा. It's A. Does not become a witness in the case unless he is called as a witness. Now question number 17. Which of the following statements holds true for examination in chief of a witness? The leading question can be used. It must only relate to relevant facts. It must only relate to the fact in issue and the all of these. चलिए करेक्ट बताइए. So इसका सिंपल था. Correct is option number B. Question number 18. Dash section of the Indian Evidence Act was inserted by the Criminal Law Amendment 53, 53A, 119 and 119A. चलिए करेक्ट ऑप्शन बताइए. So correct option is 53. An admission is not relevant in a civil case if it is relevant otherwise than as an admission proceeding from a person in authority made under circumstances from which the court can infer that the parties agreed together that evidence of it should not be given made by pleader वकील attorney. चलिए करेक्ट ऑप्शन दीजिए. So correct option is option number C, made under circumstances from which the court can infer that the parties agreed together that evidence of it should not be given. So last question but not the least, opinion of an expert expressed in a book commonly offered for sale cannot be proved by the production of such book. If the author is dead, cannot be found, has become incapable of giving evidence, and if the author has gone abroad on vacation. तो वही simple question है इसका भी. Answer is D. If the author has gone abroad or on a vacation. So thank you so much for आज की वीडियो. तो ऐसे ही आप सपोर्ट करते रहिए, प्यार दिखाते रहिए, लाइक शेयर सब्सक्राइब करते रहिए और जिसको ज़रूरत है उसको ये वीडियो ज़रूर भेजें ताकि उसको भी हेल्प हो और मैं भी अच्छी मेरे को मोटिवेशन मिलेगी तो मैं भी अच्छी वीडियोस आपके लिए लाता रहूँगा. So thank you so much from Ezi Law. See you on next video.